Hello, law students and legal practitioners. Today, we will analyze the case of spouses Vargas versus Santa Lucia Realty and Development, Incorporated, GR number 191997 and decided by the Supreme Court on July 27, 2022. Let's begin. A compulsory easement of right-of-way may be granted only upon strict compliance with the requirements under Articles 649 and 650 of the Civil Code, namely, the dominant estate is surrounded by other immovables and has no adequate outlet to a public highway. Proper indemnity is paid. The isolation is not due to the acts of the owner, and the easement must be established at the point least prejudicial to the servient estate, and, where possible, the shortest route. Courts will grant such easement only when absolutely necessary, and mere convenience is insufficient to justify the burden imposed on the servient estate. The burden of proof rests on the party claiming the easement. Failure to present evidence on the accessibility circumstances of all surrounding estates is fatal to a claim for a compulsory right-of-way. Here are the relevant facts of this case. Spouses Marcial Vargas and Elizabeth Vargas owned a 10,000 square meter parcel of land, outside lot, located in Barangay Batasan Hills, Quezon City. In 2000, they purchased an adjacent 300 square meter lot, VRC lot, located inside the Vista Real Classica, VRC, subdivision, a private residential development owned by Santa Lucia Realty and Development, Inc. SLR. The spouses alleged that the outside lot was landlocked or effectively isolated, and the only practical access to the nearest public highway, Commonwealth Avenue, was through the internal roads of the VRC subdivision. Specifically, they claimed that passage through Barcelona Street, Baltimore Street, and Vista Real Avenue provided the most feasible access route. They demanded from SLR the establishment of a compulsory right-of-way through the subdivision roads, but SLR refused. The developer argued that subdivision restrictions prohibit using internal roads as access to external properties and that granting such easement would violate approved subdivision plans and contractual restrictions. The spouses filed a complaint before the RTC seeking recognition of their right-of-way. The RTC ruled in their favor, finding that the outside lot had no other adequate access to a public road and that the VRC route was the most practical outlet. On appeal, however, the Court of Appeals reversed the RTC and dismissed the complaint. It held that the spouses failed to prove the essential requisites for a compulsory easement, particularly the absence of other adequate outlets and the least prejudicial route requirement. The spouses elevated the case to the Supreme Court. Here are the issues resolved by the Supreme Court. Issue 1. Whether the petitioners are entitled to a compulsory easement of right-of-way under Articles 649 and 650 of the Civil Code. No, the petitioners are not entitled to a compulsory easement of right-of-way. The Supreme Court ruled that the spouses failed to prove compliance with the essential requisites for the establishment of a compulsory right-of-way, particularly the absence of an adequate outlet to a public highway, and that the proposed route is the least prejudicial to the servient estate. Articles 649 and 650 of the Civil Code require that before a compulsory right-of-way may be imposed, the claimant must prove that the dominant estate is surrounded by other immovables and has no adequate outlet to a public highway. The isolation was not caused by the claimant's own acts. Proper indemnity is offered, and the easement is established at the point least prejudicial to the servient estate and, insofar as consistent, where the distance to the highway is shortest. Further, jurisprudence consistently holds that courts will compel the establishment of a right-of-way only when absolutely necessary, and that convenience, preference, or economic advantage does not justify imposing a burden on another's property. The claimant bears the burden of proving the physical and geographical conditions of all surrounding properties to enable the court to determine whether other adequate outlets exist. While the spouses were able to show that their outside lot was surrounded by other immovables, they failed to adduce evidence regarding the accessibility of the 3 other adjacent lots surrounding the property. Their sketch plans focused only on the proposed route through the VRC subdivision and did not establish that no other adequate outlet existed. Because of this evidentiary omission, the court could not determine whether the route through VRC was indeed the only, shortest, or least prejudicial access to a public highway. The spouses' own admission that they purchased the VRC lot for the purpose of securing a right-of-way further underscored the lack of necessity. Accordingly, the court held that the spouses failed to meet the burden of proof, and the denial of the compulsory easement was proper. Issue 2. Whether the failure of the respondent to rebut petitioner's evidence justified the grant of the easement. No, the burden of proof does not shift to the respondent. The Supreme Court ruled that the spouses cannot rely on the respondent's alleged failure to present rebuttal evidence to support their claim for a compulsory right-of-way. In actions for compulsory easements, the law places the burden squarely on the claimant to prove all statutory requisites. Easements are burdens on property, and as such, courts impose them with the strictest caution. Jurisprudence holds that a defendant's failure to rebut evidence does not relieve the claimant of the duty to prove absolute necessity for the easement. The spouses focused their arguments on the alleged silence or inaction of SLR. However, even assuming such inaction, this did not cure the petitioner's failure to prove that their outside lot had no adequate access through surrounding properties. Since the evidence presented was insufficient to establish compliance with the requisites under Articles 649 and 650, the petition necessarily failed, regardless of the respondent's defenses. Thank you for listening and happy learning. See you again for our next case discussions.